Many thanks for watching. Now, this is Breakfast Central on News Central. Now, if you had your court marriage, if you had it done at the Ikoyi Registry, the popular Ikoyi Registry right here in Lagos, Nigeria, then you might need to take a seat and listen to the stories, because there were reports that the Federal High Court in Lagos on Monday ruled that marriage certificate issued by the Ikoyi Marriage Registry were invalid. Now, in this report, Justice D.E. Osiagor was quoted as declaring that it was unconstitutional for the federal government to conduct marriages. He was also said to have held that only the local government marriage registries were empowered to conduct marriages by the provision of the 1999 Constitution as amended.
Well, he also reportedly ordered the closure with immediate effect of all federal marriage registries opened by the ministry, which are talking about the Ministry of Interior here, including that of the popular Ikoyi Registry. Now, however, in a press statement sent out yesterday from the seat of the Permanent Secretary of the Principal Registrar of Marriages, this report has now been clarified and debunked. So you have the statement. There was quite a lengthy one released, and it's coming from the Ministry of Interior itself. If I can just take down the last part of that statement there. In circumstances, the federal government, through the Ministry of Interior, has applied a certificate through copy of the judgment and will take appropriate further actions, including but not limited to filing an appeal in respect to this conflicting and confusing decision in light of the provisions of the Constitution. But it did say at the bottom, the general public is to please note the foregoing and maintain status quo ante. So it's almost like saying, carry on as you were from the Ministry of Interior.
Right, and now to shed more light on what the law says about marriages and to help our viewers paint a clearer picture of the situation in Nigeria, we have our Nigerian lawyer and head of attorney, that is LIBOROUS OSHOMA. He is the head of attorney of LIBOROUS OSHOMA Chambers. Many thanks for joining the program, LIBOROUS. Now, what is the position of the law on registration of marriages and even conducting marriages?
Thank you very much. First and foremost, what the court needs to clarify is what the Constitution defines as formation and registration. Because if you look at paragraph 61 of the exclusive legislative list, it empowers the federal government to legislate on formation and dissolution of marriage. So what is formation? And then the functions of local government also empowers the local government to register marriages and register death. So for the ordinary man, you cannot register a marriage that has not been formed. So I would presume that the formation of marriage would have to do with conduct of marriage. So it is in that vein that even the same Federal High Court, in the case of Prince Hastrop and Etosa local government, had interpreted that sections to mean that the federal government is empowered to conduct marriages through contract marriages, issue licenses, because they're empowered to form marriages. And then while the powers derived from the federal government to register marriage or to issue licenses also should be derived from the Ministry of Interior. So against that backdrop, the president had issued executive orders, notices number 55 and 56 or so, to empower the local government to conduct marriages. And there are so many other cases, I think about 3 other cases. But I think you have also a local government and the Minister of Interior and 2 others. And then you have another one, Babalola and the Keja local government and the registered trustees of Association of Local Governments of Nigeria, where the same judgment, all these judgments have been concurrent until this last one, where the judge, same Federal High Court, has said that local, Ikoyi Registry does not have powers to conduct marriages. I wonder where that judge, derived this interpretation from. But that said, these are all of the issues that had to do with this bogus federal structure that we practice, where our Constitution had actually donated almost every power to the federal government. And until we rework it, we'll still keep having this back and forth. But clearly speaking, the Constitution empowers the federal government to legislate on formation and dissolution of marriage.
All right, Liberal. So we're saying that the federal government clearly are not erring in any way, though the judge in the Federal High Court has made this ruling. Where does that leave the local governments right now in terms of conducting or registration or taking out doing marriages themselves? Because we've seen the statement released by the Ministry of Interior through the Parliament Secretary. They are saying, Nigerians, carry on as go. If you have marriage today in Ikoyi, go there and follow suit.
Yeah, you see, first and foremost, at the heart of this, at the heart of all of this is because the issue of finance. That's what is at the heart of all of this. I have the privilege to attend a few seminars by both stakeholders on the issues, and the complaint had mainly been revenue generation, the revenue that is supposed to accrue to the local government through conduct of marriages is accrued to accruable to the federal government through the Ministry of Interior. Another problem is that the local government have not been able to put their acts in order in terms of transparency in the process and a verification. That's why most people would rather patronize the federal marriages, because they've been able to synergize and put a process in order for verification. So the embassies would recognize the federal marriages more. So, but against that backdrop, what is really at play here? I would also want to say quickly, before I answer that question, that the judge, that pronouncement by the judge nullifying all marriages conducted by Ikoyi Registry had no basis in law. It has no basis in law, because there's what we call the presumption of regularity, that once an act is done within the powers of the person that is doing that act, until nullified, that act is presumed regular. So when, as at the time, let's assume without conceding that the Ikoyi Marriage Registry does not have the constitutional backing to conduct marriage, as at the time they were conducting those marriages, there were valid court judgments empowering them to so do. The constitutional provisions also empower them to so do. So if you are now making a pronouncement, that pronouncement should be from where that decision was given, especially also given the fact that they are court of ordinary jurisdiction and conflicting judgment. But also, on the issue of the local government, there's already an executive order issued by the president. I told you, notice number 55 and 56, that had empowered the ministry to issue directive to local government to conduct marriages. These issues have been dealt with, and these directives have been issued. All they just needed to do was to harmonize all of their processes, so that there'll be uniformity and unification of the certificate issued. So you don't have to go to Ikoyi and then go to Etiosa. So once Etiosa issues you a local certificate, it is verifiable from the federal government. That was all that was remaining. So if they continue in that trajectory, there will be no problem with all of this, whether valid or not valid marriage. We should be more concerned with the issue of insecurity. The people that are conducting marriages, how safe are they in their homes? Those are the issues that should concern us, really. And I think that this is a very small issue that the federal government can actually, look into. Either, take the matter singularly to the Supreme Court, it's a constitutional matter for its interpretation, so that we'll have a clear court decision on it, instead of this back and forth from the Federal High Court. 4 judgments, all of them 3 against 1. So instead of having this back and forth at the Federal High Court, so that people will have rest of mind once and for all. And then, like I said, the local government also needs to put their house in order and ensure that their systems and their processes are streamlined and verification is ensured, so that there'll be trust in the process. Otherwise, people will not have to be rushing to Ikoyi, because Ikoyi is easy to verify. They have portals, but the local governments don't have this thing.
Right. Thank you so much, Liberous. I mean, a lot of people have come out to also wonder if it's because of the funds generated at the Ikoyi Marriage Registry. That could be another reason why people are coming out, or the people who have taken them to court are wanting more money or not. But that's a question for another day. Thank you so much.
The money. It has to do with the money, really.
Okay,
but the other registries now, it's not everything Ikoyi. Anyway, Liberous, thank you so much for coming. If you get an invite to Ikoyi, I'm sure you will not decline, Sha.
Thank you so much once again, Liberous Oshoma, who is the head attorney of Liberous Oshoma Chambers. Many thanks for joining, and your appreciation, your time on the program is well appreciated.